Hi there, I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we focus solely on estate planning. Uh, Today, I want to talk to you guys about watching out for stolen items in your loved one's estate. And yes, it does happen. Now, your family member went through a meticulous process of setting up their estate plan and to organize and distribute money and property for the benefit of their loved ones, including you. But you may suspect that some of the high value items in their estate originated perhaps as stolen property. Now, the possibility of discovering stolen items within an estate is often overlooked, but it can have legal, financial, and emotional complications. So, how does this happen? So, let's talk, for example, artwork. A New York Times article published in 2023 reported that the New York Met Museum is carefully combing through its art collections after the government seized dozens of art pieces that were suspected of having been stolen or looted in the past. Now, it is widely known that art collections have mysteriously disappeared over the centuries, especially during wartime, and that ownership should be researched to avoid purchasing an item that actually belongs to someone else. Now, the Art Loss Register alone lists 700,000 stolen items. Many items find their way into legitimate markets through underground dealers where criminals can exploit innocent buyers. Now, when putting together your estate plan, any significant collections you own should be taken into consideration. If your loved one receives stolen items from you at your death, they may not receive legal title to them or to that item, exposing the estate to financial and tax implications. If artwork or other high value property is removed from the estate, it can affect the liquidity necessary to meet potential estate tax and administrative costs, as well as the inheritance of beneficiaries. An estate planning attorney can prepare for different scenarios to protect you and your family. So let's talk about private letter rulings and seized assets. According to a private letter ruling, if your family discovers stolen items after a loved one's death, the IRS could include the fair market value of the property in the deceased estate for estate tax purposes, even after it has been seized and returned to the owner. This could leave the family owing an estate tax, but unable to sell the item in order to pay that estate tax. Now, the government can seize property it believes has been involved in illicit or criminal activity. Even if your family member purchased an item from a reputable dealer or inherited the item decades ago, it can still be taken by the government. Now, let's talk about how people come into possession of stolen items. Understanding how individuals unknowingly acquire stolen items is crucial for recognizing potential risks. Innocent parties often purchase items through estate sales or auctions or receive gifts from friends or family members. A lack of transparent ownership or a historical record can make it challenging for the unsuspecting owner to identify stolen items. Now, every year, over 1 million homes are burglarized and almost 100 billion in stolen merchandise is stolen. Billions in stolen property is circulating, leaving innocent buyers liable. Those possessing stolen items can serve time in jail or be forced to pay a fine. Now, common places to come across stolen goods are online marketplaces such as Craigslist, eBay, or Facebook Marketplace that have lax regulations for selling items. Now, pawn shops can often be unsure of the origins of their inventory, but they are required to some degree to research ownership or face prosecution. Now, the question comes up is, can you be held accountable? Not everyone is held accountable for being in possession of stolen goods. There's no statute of limitation for prior owners to claim their stolen property, but there are legal defenses used for possessing it. The defense of laches asserts that prior owners who unreasonably delayed asserting their rights may not be entitled to bring a claim against the person or estate in possession of their property. After all, the property may have already been sold and the proceeds divided among heirs, making it very difficult to recover. Whether you can be prosecuted or convicted of possessing stolen property depends on several factors. One is knowledge that the item was stolen. Suspected stolen items should be reported to law enforcement, or you could be held accountable. However, if it was nearly impossible to know it was stolen, you will likely not be held accountable. Knowledge that the item was in your possession. You can unknowingly be in possession of a stolen item. If you're honest, open, and prompt, you should not be held accountable for this. Now, what should you do if you suspect ownership of stolen property? You can take steps during your family member's lifetime to address your suspicions. You want to be proactive. If there's a hint of uncertainty about the legitimacy of an item, your estate planning attorney can take the following steps. They can research the item's history and provenance to trace its ownership back to its origin to see whether it has ever been reported as stolen. They can seek guidance from professionals such as art historians, appraisers, or legal experts who specialize in stolen art and property. They can validate legitimate ownership. You can report the situation to law enforcement in a timely manner to contribute to the recovery of stolen property and prevent legal complications down the line. Now, there's a risk of discovering stolen items within a loved one's estate, especially with high value collections. Do not overlook this when doing your own estate planning. By being vigilant, understanding the legal implications, and taking proactive steps, you can mitigate the risk of inheriting or owning stolen property and ensure a smoother estate settlement process for you or your loved ones. Now, a proper estate plan can protect you and your family. Proper estate planning can protect you from the risks of owning stolen property through due diligence and research, ensuring that the prior owner's rights are extinguished. Unfortunately, research into the origins of property can be expensive, often costing more than the item's value. However, where there is one suspicious item, there may be more. If you are the beneficiary of gifts with suspicious origins, you can disclaim them if that's what you choose to do. Now, if you have questions about something in your collection or your recent inheritance, you can always contact your local estate planning attorney and talk to them about this further. I want to thank you for watching. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we focus solely on estate planning. If you want to learn more about estate planning and different topics, please like and subscribe our page below.